días. Bueno, vamos a dar inicio al panel de violencia contra las infancias en el contexto de la propia apertura del World Congress 2023 de Nueva York. Me enorgullece presidir un panel de esta impresionante calidad y esta impresionante trayectoria. Unos 30 años atrás, la disciplina del derecho de los niños era prácticamente inexistente en el campo del derecho. El Estado tenía poco involucramiento en materia de la niñez maltratada. A partir de las últimas tres décadas, los Estados comenzaron a suscribir convenciones internacionales vinculadas a la protección de los derechos de la infancia, haciendo propio el Estado este enorme reto, ¿no? Insisto, una materia que para los abogados de aquella época era muy poco común. En mi caso coincide con mi trayectoria profesional de 33 años. Allí por esos comienzos me involucré con el derecho internacional de los derechos humanos y muy particularmente con los derechos del niño. Me tocó participar de la génesis del Comité de Derechos del Niño de Naciones Unidas y allí por 2002, a raíz de una investigación periodística que comenzó allí por el 2001, me toca dirigir la acusación del que termina siendo hoy el leading case universal en lo que significa enjuiciar a un sacerdote de relevancia a nivel mundial. Vamos a ir conversando, intercambiando con los panelistas distinguidísimos, pero bueno, me llama particularmente la atención la presencia de Martin Byron, porque 25 años después de hitos que a mí me tocó protagonizar, Martin Byron, que ha sido el editor responsable de Washington Post, lo fue antes de Boston Globe, y precisamente Boston Globe fue la primera enorme investigación sobre los casos de abusos sexuales en Boston, y fue paradójicamente absolutamente contemporánea con mi trabajo. En el correr del tiempo nos conocimos con muchos de ambas investigaciones. Ann Barrett estuvo en Argentina muchas veces en mi despacho, pero creo que probablemente ni en ese momento Martin, cuando emprendían tamaña investigación, ni en mi caso, cuando emprendía tamaña acusación, que llevó 15 años de mi vida profesional, creíamos que estábamos ante la génesis de algo que aún hoy no iba a estar resuelto, ¿no? Quiero decir, la problemática de la niñez ha avanzado, los sistemas jurídicos de cada país han ido adoptando medidas y normativas dirigidas a proteger a la infancia, pero bueno, particularmente han ido quedando sitios en que esto no ha sido resuelto. Nos une también hoy con Martin y con Ulrich, quienes en Alemania han dirigido la investigación en Múnich sobre los abusos sexuales y con quienes me honra compartir actualmente la misión que se nos ha encomendado en España de auditar a la Conferencia Episcopal Española, ¿no? Por eso digo esto, que 25 años después se unen una enorme cantidad de cosas. Yo recuerdo que allí por 2009, en este proceso que me llevó 15 años de mi vida, en la Argentina, el cardenal primado de la Argentina era Jorge Bergoglio. En el transcurrir del proceso, Jorge Bergoglio pasa a ser el Papa. Yo me reunía con él por este tema. Era un tema absolutamente difícil. Seguramente Martín nos hará comentarios de lo que significó la investigación para ellos, pero era un tema absolutamente novedoso, difícil de comprender, difícil de entender que esto ocurriera en la Iglesia, y bueno, y hoy vemos que sigue siendo un problema universal que aún no ha tenido resolución. Y yo ubico dos hitos posteriores en mi camino, ¿no? En 2009 yo logro la condena del cura Grassi a 15 años de prisión, en el marco de muchas situaciones de tensión con el cardenal Bergoglio. En 2017 logro la condena firme de la Corte Nacional, con lo cual es el primer gran caso que se convalida en un Estado soberano a 15 años de prisión. Esta persona está cumpliendo la condena, es el primer caso que tratándose de alguien tan poderoso y que fue defendido por más de 30 defensores particulares en ese proceso, efectivamente es condenado y cumple la condena. No obstante eso, sigue siendo sacerdote, lo cual ha sido objeto de críticas a quien hoy es el Papa Francisco y con quien he conversado ese tema. Recuerdo, como otro hito en 2016, estar en Tegucigalpa trabajando en el marco de la Fiscalía Especial de la Niñez. Me entero del estreno de una película en primera plana. Allí la voy a ver y era la investigación de Boston que protagonizó nuestro distinguidísimo compañero Martin Byron. En los créditos de esa película está nuestro caso final. Y bueno, por eso digo, esto ha sido la génesis. Lo que hoy, digamos, creo que por un lado vamos a reflexionar cada quien, pero bueno, creo que veo con mucha esperanza y con mucha expectativa el trabajo que estamos haciendo en España, porque decía que este problema la Iglesia no lo ha logrado resolver a nivel universal, y en España se está haciendo un esfuerzo que lleva prácticamente 1 año y medio, y estamos prácticamente en los finales de la investigación, y estamos desarrollando una auditoría que pretende acercar a la institución eclesiástica una propuesta de solución en la cual la totalidad de las víctimas que sean detectadas como tales sean reparadas, y a la vez organizar por primera vez protocolos de no repetición, garantías de no repetición, y que las autoridades eclesiásticas logren, digamos, a partir de pedir perdón, comenzar una nueva etapa. Creo que nos une en esta investigación un equipo heterogéneo de distintos países, de distintas formaciones, de distintas incluso religiones, pero todos con esta misma actitud, creo yo, constructiva, porque tiene que ver con lograr, a través de las experiencias propias de cada quien que integra este equipo enorme que se ha formado en Madrid, alrededor de Javier Cremades, que es quien lo preside, buscar una solución que dé respuestas a las víctimas, que no las han tenido a lo largo del mundo, que dé respuestas a la sociedad y que de alguna manera permita a la institución renovarse y ser mejor. Este trabajo que estamos haciendo provocó tal atractivo que fuimos convocados al Vaticano en el mes de febrero de este año. Estuvimos 3 días sesionando allí y pronto presentaremos este informe. De modo tal que vamos a comenzar la ronda de participaciones del panel con Martin Byron, que como bien les decía y seguramente todos lo conocen, hasta hace muy poco el director ejecutivo del Washington Post y anteriormente de Boston Globe, y bueno, gran protagonista de la investigación de Boston.
Thank you, Juan, Pablo. Appreciate that. So I'll just speak briefly. I thought that what I would do is just describe how our investigation of sexual violence, sexual assault in the Catholic Church began in 2001, and how I see the problem and to what extent it's been resolved, which is to say that it has not, in my view. You know, it's interesting that the title of this panel is about the legal response to sexual violence. In the case of Boston in 2001, the problem was there was no legal response, there was no political response, there was largely no response on the part of the press, and that was the problem. And that's why for decades, half a century at least, there was essentially a cover-up of widespread sexual abuse within the Catholic Church, not just a matter of priests committing sexual assault, but the institution covering it up, and other institutions, including the legal institutions, participating essentially in that cover-up and not doing anything about it. So when I got to Boston in the summer of 2001, the day before I started work at the Boston Globe, as the editor, I read a column about one case involving a priest by the name of John Gagan. He had been accused of abusing as many as 80 children, and the plaintiff's lawyer said that the cardinal himself was aware of this abuse and yet continually reassigned the priest from parish to parish. The church denied that, and I went into my first meeting, listened to what everybody was working on for that day. My first meeting, first day, nobody mentioned anything about this case or any follow-up or anything of that sort. So I asked, what are we doing to follow up? And somebody said, well, all the documents are under court seal. They're under a confidentiality order. And I said, I don't know the laws of Massachusetts. I just got here. but have we thought about going to court to challenge that, confidentiality order? I think everybody was pretty surprised that the new editor on his first day at his first meeting would talk about bringing a case against the church, which was then probably the most powerful institution in New England. But that's what we did. So after consulting with our lawyer, whom I had never met before, terrific lawyer, John Aldano in Boston, and so we launched a case in court. We also did a parallel journalistic investigation, and thankfully we prevailed. The lawyer at the time told me that he thought we maybe had a 50-50 chance. I told him I thought those were good odds for journalists, and we should just go right ahead. Generally, we don't face such good odds. So anyway, I think what made a big difference in that case is that we actually did obtain the internal church documents. It's not as if there hadn't been accusations of sexual abuse before, documented cases, all of that. But the fact that we could see with the court's own internal documents how much it knew and how little it did, and how it reassigned priests from parish to parish, knowing full well that they were abusers, at times putting them in some sort of facility that was supposed to cure them, and then taking them out and reassigning them, and then not telling the truth to their own parishioners about where they're, what they said they were taking these priests out of ministry, and then they put them right back into ministry. And that had an explosive effect. There was betrayal of the parishioners, certainly of the children, and a betrayal of the principles of the church as well. And the response of the church was to promise reforms. Those reforms that were proposed or mentioned were weak, insubstantial, likely to be ineffective, and that would continue to happen. When you would point that out, they would propose something else. It too was was non-responsive, and also the church was full of apologies which it has issued time and time again to this day, continues to apologize. So we were attacked as well. Marianne Glendon, who's a professor of law at Harvard, who later became ambassador to the Vatican, said that if we were to win a Pulitzer Prize for our work on the Catholic Church, it would be like giving the Nobel Peace Prize to Osama bin Laden. The cardinal in Honduras, who then was considered to be a potential candidate for Pope, he said the Jews were behind this. Perhaps it was no coincidence that I am Jewish. In any event, ultimately, we wrote about 900 stories about this over a course of a year and a half. I think the impact was because he had the documents, but also was because of the internet was a big part of media at that time. And it was called actually the first big internet investigation that was disseminated over the internet, which meant that the church couldn't keep things isolated in one community where people couldn't communicate with each other. The entire world could see what was happening. Survivors could communicate with each other and organize over the internet, and I think that had a big impact. And I would say, I'm often asked now to what extent I think the church has addressed this, and my general response is that the very fact that someone's asking this question tells you the answer, which is that it has not addressed this adequately. Yes, there have been reforms. Yes, there have been improvement in the United States, perhaps in Europe, but I think the conclusion that I've come to is it's sort of a Sherlock Holmes thing. It's the dog that didn't bark. Where is the church growing, and what are we hearing about cases there? The church is growing most rapidly in Africa and Asia, also is very strong in Latin America, and yet we hear of relatively few cases in those places, and I believe that is because there is no legal pressure, that's no political pressure, there's no pressure from the press. And when there is no pressure, the church does not voluntarily disclose these cases. And so I've come to the conclusion that essentially the cover-up continues. And so here we are, more than 20 years after we did our first story, still talking about these cases.
Muchas gracias, Martín. Luego vamos a abrir un poquito el debate, pero vamos a continuar con las exposiciones. Y está con nosotros una de las más grandes juristas a nivel mundial, todos la conocemos, es Patricia Refo, miembro de World Jurist Association, hasta hace muy poco también presidente de la American Bar Association, y quien nos va a hablar de las dificultades en el sistema norteamericano para el tratamiento de la temática de los derechos de la niñez y de la violencia contra los niños. Muchas gracias, Patricia.
Thank you. It's wonderful to be here. And since I don't speak Spanish, I hope you just said nice things about me. This is such a deeply important topic, and I think it's particularly important that we started with a brave journalist who led brave journalists in what is obviously the very first sort of public discussion of all of this in Boston. Our country, at least in my view, continues to struggle with how the legal system should respond to these kinds of horrific, awful, terrible instances of sexual abuse, whether it's from a church or from the Boy Scouts or from any other nonprofit or student teams of various kinds that have experienced these kinds of horrific sexual abuse. Our legal system is just not yet built to really fully respond. And I don't know enough, since I'm just an American lawyer, whether that is true around the world, but I think it's important, my guess is that it is, and that some of the things that we struggle with here in the United States are also things that we struggle with elsewhere in the world. So one of the first things that you have to think about in these cases is the statute of limitations issue. These are not cases, when you are talking about the abuse of children, in which it makes sense to say that you must bring a claim within X number of years. And we all know that, and we all know why. Because of issues starting with actual repressed memory, and going from there into circumstances even which the memory is not clinically repressed, whatever that means, and I'm not a clinician. It is organized in the person's psyche in a way that it is not going to drive that person to seek recompense in a court of law in a timely fashion. So many jurisdictions in the United States have enacted statutes that either extend the statute of limitations or allow people to revive claims that would otherwise be stale and forbidden, in recognition of the fact that, in particular, these kinds of claims are not suited to the trauma that the victims experience. A secondary and deeply important issue is around questions of witness credibility. All of the things that we are trained to do as human beings to assess whether someone is or is not telling the truth frequently fail when we are talking about an adult reciting something that happened to that adult when they were a child. The detail that we expect and that we associate with a credible story is missing. The manner in which the individual describes the event does not ring true, right, in the way that we think of when we as advocates are in a courtroom or on a jury or a judge assessing someone's credibility. It's a deeply difficult issue for the civil justice system to try and deal with in these sorts of cases. And the final big ticket item that I think it's important for us to at least say at the front end is that most civil justice systems are not designed to address sort of restorative justice. Civil justice systems are designed to figure out how much money should go from point A to point B to make someone whole as a consequence of something that has been done wrong. That is, by definition, an utterly incomplete response to these kinds of cases. And I agree that it is not helpful, obviously, for an institution to just consistently apologize and not make change. But it is equally true that a real apology can often be very meaningful to survivors. Individual apologies can be very meaningful to survivors. All of those things utterly outside the bounds of a civil justice system that, for the reasons that you just described, is actually built to keep things quiet, right? To prevent documents from being released, to avoid admissions, to not say that you're sorry and bad things have happened. And that is yet another reason why the civil justice system in most of our countries is inadequate to this task.
Bueno, vamos a seguir la ronda del panel, como habíamos mencionado, en este caso con Ulrich Wastl de Alemania, quien junto con Martin han liderado la investigación en Alemania.
Thank you so much, and it happens to be a good coincidence what you told, because I really want to connect with this. I want to share some of the considerations of an interdisciplinary project focusing on the question of testimony assessment in cases of the sexual abuse of minors. In these cases, frequently the question of the victim's credibility arises. As a consequence, and especially if children are involved, at least in Germany, expert statements, so-called statement validity assessments, or SVA, conducted by psychologists are commissioned by the court. Quite often their finding is that it cannot be ruled out that the victim's testimony is not experience-based. Consequently, a criminal complaint is not filed by the law enforcement authorities, or the accused is acquitted. Additionally, a considerable number of victims who were subject of such a SVA reported, amongst others, that they felt mistrusted and that the SVA, as well as the legal authorities' decision, had negative impact on their psychological and physical health. In this context, I want to focus on the question to what extent legal rights of victim witnesses may be negatively affected by such SVAs, and what has to be done to prevent the breach of victims' rights, especially in a court trial. This ends up in the call for testimonial justice. Though some of the legal considerations I want to present are based on German constitutional law, I'm convinced that they can easily be adopted by other, not at least Anglo-American legal systems, since they are founded on very fundamental legal beliefs. But first, what does testimonial justice mean? Primarily, it is true that the injured party is in particular a source of evidence. But when considering the validity of a testimony, it must be taken into account that the ability to communicate verbally and related to this to verbalize stressful experiences varies depending on the victim's intellectual and developmental prerequisites. To that extent, it appears to be epistemically unfair if the knowledge, to which the word epistemic refers, of the witness due to the SVA method used remains systematically and discriminatorily unheard or misunderstood, and therefore procedurally invisible, and is exposed from the outset to the unconscious prejudice of not being sufficiently credible. This problem arises particularly when witnesses are due to mental disorder or for intellectual or other reasons, at times caused by the abuse itself, disabled to produce enough and or high quality so-called free text, what is the basis for the SVA, without possibly suggestive inquiries. The counter-construct is testimonial justice. It aims to ensure that witnesses have a realistic chance in court and other proceedings to be heard effectively, and that their testimonies have a fair chance at all to be evaluated as credible. How can testimonial justice be founded legally? First of all, it should be noted that, at least in Germany, the constitutional status of the injured party has not been adequately discussed yet. The basis for a constitutional right to victim-friendly criminal proceedings, embracing testimonial justice, is the right to effective criminal prosecution that, so far, only applies to significant criminal acts against life, physical integrity, sexual self-determination, and freedom of the person. This individual right to effective prosecution is derived essentially as an aspect of the constitutionally founded duties of protection based on the guarantee of physical integrity in connection with the protection of human dignity. This stands close to the injured party's constitutionally guaranteed entitlement to judiciary, which is derived, amongst others, from the rule of law, and therefore suggests some consequences for the status of injured parties as victim witnesses in criminal proceedings. For where the statements of victim witnesses become invisible for criminal proceedings because they are considered implausible as a result of an approach that schematically ignores the communicative characteristics of victims, for example in an SVA, the fundamental right to effective criminal prosecution remains unfulfilled. Here on site, probably even more important are international legal foundations for the demand for testimonial justice. In particular, the United Nations Convention on the Protection of Children and the United Nations Convention on the Rights of Persons with Disabilities should be mentioned in this context. Article 19 of the UN Convention on the Protection of Children obliges the contracting states, first and foremost, to take all appropriate measures to protect children from physical and mental violence and especially sexual abuse. This preventive provision is supplemented in paragraph 2 by the obligation in repressive means that also effective measures for the investigation and prosecution of conduct harmful to children have to be implemented. It is clear that methods of testimony validity assessments are not compatible with these provisions if on their basis children's statements structurally have a lesser chance of influencing judicial decision-making because they fail to take into account the intellectual and cognitive peculiarities of children. If the content of children's testimonies is not exhausted because the testimonial competence of children in general and traumatized children in particular is not properly appreciated, the goal of effective investigation and prosecution of child-damaging behavior is missed. The same applies to the UN Convention on the Rights of Persons with Disabilities. Due to the broad scope of application corresponding to its objective, one will also be able to regard traumatized victims as covered by it. Above all, the obligations arising from Article 5, Paragraph 2 and Article 13, Paragraph 1 of the Convention to respect the best interests of the child and to ensure effective access to the justice systems are significant in the present context. However, effective access to justice system urges the possibilities of active and effective participation in the proceedings, for example, the possibility of actually receiving a judicial hearing. However, this in turn presupposes that the physical and psychological characteristics of the persons are taken into account, particularly in the context of the assessment of evidence, and that these are not measured by the standards that apply to non-impaired people, which incidentally would again constitute a violation of the principle of equality. At last, how can testimonial justice be achieved? It is important to be aware that achieving testimonial justice may be different, for example, in criminal and civil trials, due to different principles governing the different type of trials and especially the burden of proof. One of the most important aspects is that in case of an SVA, the special cognitive and intellectual abilities of the victim witness to memorize events in the past and to express her or himself have to be taken into account in an adequate manner. This due to the fact that especially in cases of long-lasting, multiple abuse actions, it is very hard to remember single acts and to describe them, what leads to the dilemma that the most affected victims have the worst chance to pass the SVA. Secondly, the victims need obligatory professional assistance in course of an SVA. This professional assistance assistants can describe the procedure of an SVA and help to prevent the feeling of not being trusted and in consequence negative impacts on the victim's psychological health, but to feel safe and secure, what will help to improve the quality of the witness statement. Furthermore, victim witnesses shall not be deprived of therapy before making her or his statement in front of the legal authorities, though it may be argued that such a therapy may have suggestive impact on the statement. Therefore, it seems preferable to set up a system where victims of sexual abuse first make a statement in front of a special trained expert short after the abuse happened in order to freeze the statement. Afterwards, if the victim decides to make a denunciation to the legal authorities, this authentic statement can be handed over to the authorities. Ultimately, dealing with the question of validity of statement of victims of sexual abuse in the context of court trials has shown that still a lot of psychological research has to be done and that an intensive interchange between psychologists and jurists is necessary for the good sake of the abuse victims. Thank you.
Bien, vamos a seguir ahora con Liza Velázquez, abogada aquí en New York City, partner en Paul Weiss. Nos va a explicar y comentar algunos aspectos de procedimientos de prevención y también de procedimientos en materia educativa vinculadas a la protección de la violencia contra las infancias. Así que, Liza.
Thank you. I'm honored to be participating alongside this group of incredibly accomplished panelists. In thinking about our panel topic, I absolutely and wholeheartedly agree with our distinguished panelists that the legal response to sexual violence against children as it currently exists is inadequate. So one perspective that I wanted to add to this discussion is to start from the premise, hope, belief that abuse is preventable, and the radical concept that lawyers who advise organizations that serve children have an obligation to educate their clients on how to prevent abuse. In my opinion, preventing abuse is one of the most important goals of any legal response. To prevent the abuse from happening in the first place, or if it has already happened, to prevent it from happening again. A safe environment for children requires the implementation of robust and consistently enforced policies and procedures to support a culture of safety and reporting. And the best practices include implementation of a holistic set of policies. We can package it into 4 pillars: risk prevention to promote child safety, staff, guardians, and children who are educated and trained to recognize signs of abuse, multiple lines of effective and user-friendly means of reporting, and timely and effective procedures to investigate complaints, support victims, and discipline offenders. And I'll just go through each of these briefly and offer a toolkit for consideration. So first, risk prevention measures. The goal here is to create an environment where potential offenders are not provided with an opportunity to engage in abuse. The most effective approaches will have a compliance focus, outlining clear behavioral guidelines for all staff. Adequate resources and staffing are essential in preventing child abuse. Supervisors must be sufficiently able to monitor settings that create a risk of abuse, and all programs should have adequate staff-to-child ratios. Only fully vetted staff, after thorough background checks and screening, and refresher checks at regular intervals, should be working with children. Reference checks should include behaviorally based questions. Hiring interviews should include behaviorally based questions, and hiring managers should be provided with guidelines and training on how to review a file for signs of risk. One-on-one interactions between adult personnel and minors should be minimized, and where they need to take place, it is recommended that there be risk minimizing procedures in place, and high-risk locations and activities should be monitored and managed. 2, training. It's critical to train staff, parents, guardians, and minors as appropriate to recognize signs of abuse. According to numerous studies, school staff are frequently unaware of what constitutes sexual misconduct, how to identify signs of abuse and boundary violations, how to report concerns, and the failure to recognize those warning signs allow abuse to occur and continue. Staff training should include how and where to report abuse, investigation processes and the disciplinary consequences of misconduct, and training on how to provide trauma-informed care to victims. An abuse prevention policy should be clearly communicated. Well-communicated and enforced policies send a message to potential offenders that they are being monitored and cannot act with impunity. The third pillar is reporting. Every person who works in proximity to a child should be trained in how, when, and where, and to whom to report suspicions of sexual abuse. This includes not only licensed staff like teachers and psychologists, but also unlicensed personnel like bus drivers and janitorial staff. It's important to acknowledge that even incidents which are recognized as suspicious often go unreported. Although a majority of US states have mandatory reporting laws, studies show that employees fail to report suspicions of child abuse to child welfare personnel out of fear of legal consequences or fear of damaging the reputation of the organization. Cases that are handled informally enable offenders to leave quietly with no record of abuse. And for this reason, there has to be a concerted effort from organizational leadership to encourage a culture of safety and compliance. Individuals should be encouraged to report what they feel is suspicious, even when they are unsure. It shouldn't be left to the reporter's discretion. Having anonymous reporting avenues is essential. Other children and students are often the first to recognize that something's wrong, and they'll be more likely to report if they're able to do so anonymously. Employees are afraid of making false allegations against a fellow employee, and anonymity will help address those fears. In addition, the actions and inaction of supervisors and bystanders should be a mandatory part of every investigation. Lastly, effective and timely response to complaints. When abuse or suspicious behavior is reported, it's critical to respond promptly. Investigation should not only take place when an alleged sexual abuse assault has occurred, but investigation and documentation should begin as soon as an inappropriate boundary violation has occurred, as those violations can lead and escalate into sexual misconduct. Investigating and documenting such behaviors can help prevent more serious harm from occurring. The National School Board Association Council of School Attorneys outline a proactive response to a report of suspected abuse. Within the first hours of receiving notice of a complaint, administration should immediately ensure that the child in question is protected. Mandatory reporting to law enforcement should occur. The employee should be placed on administrative leave. The child's parent should be informed. Immediately placing the accused staff on administrative leave for the duration of the investigation is particularly important. This should be part of the organization's official policy, should be followed without exception, and should be documented to confirm compliance. Of course, the investigation must be consistent and thorough, and all reports of suspected misconduct should be stored and made easily accessible in the event of new reports against the same individual. Documentation of complaints, investigations, and outcomes should be audited regularly to ensure accountability. Finally, to aid in a successful investigation, organizations who serve children should strengthen their relationship with external child welfare and criminal justice agencies. Close cooperation with outside agencies can provide access to investigation resources, subject matter expertise, and victim support. Thank you.
Bueno, gracias. Vamos a seguir ahora con Martin Pusch, que como hemos dicho ha participado junto a Ulrich de esta investigación en la diócesis de Múnich y actualmente participa también de la auditoría en España a la conferencia episcopal. Martin.
In Germany, there's some words, it is everything said, but not by me. Therefore, I would only announce something. We have prepared a paper of 15 theses going to the state, going to the legislator, to the courts and investigative authorities.
Martín, un poquito más, que estamos grabando y es muy importante tu exposición.
Okay. To the institutions concerned in the areas of child and youth welfare and education, and directed to the public. With 15 theses, we publicate afterwards, after this group, and we make a project out of that. We want everyone who is interested in sexual abuse, especially in preventing it, to give us his opinion to this thesis, and we make later on a publication out of this. And also the discussions after this session here are very important for us with this project. We will publicate it on our website, and everyone who gives me your email address, you can have it. And I only can say, please, let's work together, and then we have a good result. And that's the only thing I have to say. But for me, some words are very important. We don't treat with normal cases. You have said it. That's more than a case. It's a destiny, a whole life destiny to handle. And what we have always been to be aware. Okay? Thank you so much.
Bueno, continuamos ahora con Cydney Korek, es abogada americana en Brooklyn y nos plantea contarnos y explicarnos distintas ideas vinculadas a la modificación de leyes y a la implementación de leyes vinculadas a la protección de la niñez. Cydney.
Thank you. I just want to say I'm honored to be here speaking on this wonderful panel as well about this incredibly important issue. Just some background about myself. I worked across a few of the district attorney's offices in New York, so that's my background. I worked in domestic violence as well as special victims unit in Queens, but I was in domestic violence in Brooklyn. And I interned at the Manhattan DA's office as well in the forensic science and cold case unit, where we worked on a few sexual assault cases of children. I also clerked at the Court of Appeals in New York, which is New York's highest court, and we received a lot of SORA cases, Sexual Registration Act for Sexual Offender Registration Act, sorry. And now I work at Gersowitz, Libo, and Korek, where that's the civil side of it. We take some foster care abuse cases after the criminal case ends, and we look at it from the civil side. And I agree with everyone on this panel. There is a very long way for at least New York to go, from what I know. And I did want to discuss some of the positives, I think, that I've at least seen at the district attorney's office and just in my other work. And maybe it could be some good jumping off points and good ideas for other places to take on. So I agree with the training for the mandated reporters and for everyone, even not mandated reporters. There's this organization called the New York Foundling, and they have a child abuse prevention program where they actually go to schools and they do these live puppet shows for elementary schools, so kids like between the years of 8 and 11, and they act out sexual abuse or child abuse through these puppets and kind of give the children a way to almost like explain or understand how to explain it and to whom to explain it. And they act out all of these scenarios, and the teachers have to come also. And I think it helps the teachers understand how to talk to children about these possible abuse cases. And at the end of the show, they say if any of the children want to ask questions publicly, they can, or individually on the side, they can. And I have a friend who is a teacher at one of the public schools in New York who had this program come, and she said the response was so not what she expected, because all of these children actually were asking a lot of questions, and individually and publicly, and they were it seemed to help them and understand what could be going on either with them or one of their friends. So I think that could help in the outcry situation, that we know it takes children a lot longer to outcry than other cases and situations. And also in that program, which I think was very important, they did not tell the students or the parents before the program started, so that parents couldn't necessarily, coach their kids on what to say or keep them home from school that day. So an email went out while the program was going on to the parents saying, this program is happening right now, we can talk to you about it later. And one of the cases I actually worked on in the Manhattan District Attorney's Office, the outcry did not happen until, I think it was 20 years later. It was almost 2 decades later. And the child had died in that case, but it took 20 years to even find the abuser. Another important act, I think, is the New York Child Victims Act, which you kind of touched on, the statute of limitations, and it did give an opening for witnesses or victims to start these cases and to finally outcry years later, no matter their age. And that act also extended the age to 55 years for the statute of limitations to not run in, or for victims to have until they were 55 years old to start these cases in the criminal aspect of it. And in the civil aspect of it, and that was before, that was 20, they had to be 23 years old, and then it stopped. And the criminal part of it, it's 28 years old now for a felony and 25 for a misdemeanor, and there is no statute of limitations for rape in the first degree, which I think is definitely an improvement. And I also think a helpful part in New York law is that for most other crimes, or all other crimes, you have to give a specific date and time and place of where this event occurred. But for child abuse, you can charge it over a large period of time, because of course children don't necessarily know the dates, especially if you're going back 20 years or whatever it is. So I do think that's a positive of saying between like these years or these months at least, so they're not set to a specific date. And in Brooklyn, they actually don't make a child testify in the grand jury until they're 12 years old. So they'll do a pre-recorded video statement, and then that can be presented in the grand jury, so that children don't have to testify over and over again about this abuse that, of course, is pre-traumatizing or traumatizing them again. Although I do think the age should probably extend past 12, because that's still very young, but it's progress. And also in Brooklyn, there's a dog, Atticus, who can come into the courtroom actually while a child is testifying, and I think that could be helpful for some victims to have that comfort. And you mentioned this also, so there's this, or you touched on this, there's a child advocacy center that actually all of the bureaus in New York have. So when a child first outcries, they bring in 5 or so different organizations, the detectives, the assistant district attorney, and administration for child services workers, medical professionals, corporation counsel, and forensic specialists from organizations so that the victim testifies, it gets recorded, but all of these organizations are there. That's, you know, a few less times this victim has to tell their story. So those were just all of the positives. I thought that, you know, I do think there's a lot of progress that needs to be made, but I do think some of those could be helpful and are helpful in, you know, starting cases and prosecuting them, both criminally and civilly. So thank you again for having me here.
Thank you.
Bueno, muchas gracias, Cydney. Antes de dar paso a alguna pregunta o questions, no puedo dejar inadvertido que nos está acompañando doña Encarnación Roca, presidenta del Tribunal Constitucional de España y del Supremo, así que solo agradecerle, darle la bienvenida y cualquier cuestión que quiera plantear. Bueno, un orgullo, un privilegio y un placer que esté con nosotros, solo por si alguna pregunta o alguna... Pero bueno, pero bueno, un enorme orgullo que esté escuchando aquí. Abrimos, si hay alguna pregunta hacia cualquiera de los panelistas.
First of all, thank you for sharing this. Before going into a question, I want to take just a minute to recognize Juan Pablo Gallego and his work in Argentina. He has spearheaded a case against the Catholic Church there many years ago when it was very difficult to go against the church, and all the other attorneys that come behind him. We're having an easier time now because of his job. And the reason I want to make this public is because he's not a judge, he's an attorney, and we don't see recognition to practicing attorneys as much as we see awards being presented. So I wanted to thank you, Juan Pablo, for that, first of all. One thing that I wanted to point out, we were discussing, some of you were talking about the statute of limitations. The case in Argentina, it's very particular. There have been many improvements on this. First, we have a change of legislation that started counting the time for the statute of limitations when the victim became an adult at 18 years old. Now that has changed. Now there is no statute of limitations, so a victim could basically outcry at any moment on its life, and I think this is an improvement. Now, the case, I work on criminal defense too, and I want to point out, and I'd like your opinion on this, that there is a tension between increasing the time for the statute of limitations and exercising a criminal defense. Because the statute of limitations, they were not thought to provide impunity. They were created to provide the person trying to defend in a court of law with a regular time frame in which a proper defense was possible. Because if you charge me with something that happened 5 years ago, I might remember what I was doing at a particular time. Now, when a person is charged for something that this person has done 20 or 25 years ago, it is true that it's more difficult to have a defense. So I do believe there's this tension between impunity, if we have short statute of limitations, and the impossibility for due process in cases where victims are charged, where defendants are charged many years before. In some cases in Argentina, this has been sorted out with what we call truth trials. Trials where you can discuss anything, that these trials do not end up with someone in jail. So my question, to be brief, is how do you think, as experts, that we can reconcile these both concerns that as attorneys we may have, not granting impunity to sexual predators and abusers, then not disowning defendants from the right to a fair trial and to produce evidence that might be very difficult to produce after many years? I know it's a tough question, but I'd love to hear your input on this.
May I?
Bien.
Yeah. I can't remember off the top of my head the 5 factors right now, but in New York we have a case called Taranovich that actually weighs the factors that you're talking about, and each case is different, but it looks into all of those factors, and one of them, you know, is what you're saying, if the defendant is able to defend himself. But another one is if they've been out living their life and don't have the prejudice of, you know, having been behind bars or detained or anything like that. So I do think I wish I remembered all 5 of the factors, but that is a helpful case in New York, at least. And it's case specific, so.
A ver, las agresiones sexuales a niños son, en todos los códigos de los distintos países, son delitos con una característica muy especial que excede la lógica normal y los estándares de los códigos penales. Esto tiene que ver con la credibilidad que se da a un testimonio muchas veces único, porque estos delitos ocurren en las sombras, ocurren ocultos. Por otro lado, la comunidad internacional ha adoptado casi de manera unánime la Convención Internacional de Derechos del Niño, que impone hacer prevalecer tal derecho sobre, lo cual no significa poner en riesgo o poner en tela de juicio el derecho de defensa, pero por supuesto que se genera una mayor tensión en este tipo de delitos. También en las últimas décadas se han desarrollado procedimientos de validación científica de los testimonios de víctimas que con una certeza o con niveles de certeza bastante importantes nos permiten distinguir un testimonio verdadero de un testimonio que no lo fuera. Y otro tópico muy ligado a eso es el tópico de la prescripción. Nosotros, en nuestro equipo de trabajo en España, vinculado al trabajo que estamos haciendo en relación a la auditoría a la Iglesia española, nosotros planteamos que no debe, en el contexto de nuestro trabajo, oponerse la prescripción a las víctimas que denuncien luego de transcurridos los plazos legales establecidos por el Código Español. Y lo hacemos precisamente entendiendo esta especial clase de delito. Esta es una discusión que se está dando en todos los niveles en el mundo, también en Argentina, donde también trabajo. Ya ha habido 2 leyes modificatorias que separan los estándares habituales de prescripción del Código Penal en esta especial clase de delitos. Y tiene que ver con que la víctima muchas veces habla cuando puede. Yo siempre digo, la verdad que en más de 30 años me he dedicado a la defensa de niños en procesos judiciales en distintos países, también en Honduras. En Honduras se ha organizado la Fiscalía Especial de la Niñez. Y así como hablo con esta convicción y tomando la pregunta, yo siempre digo, yo soy un abogado de caso por caso. Quiero decir, que yo tenga esta formación, esta tendencia y esta especial inquietud en proteger los derechos de la niñez, no significa que de antemano, ante el conocimiento de cualquier denuncia, yo particularmente crea que la denuncia es absolutamente cierta. Pero creo que sí la comunidad internacional, aparta como mínimo 2 estándares. Hay que considerar el interés superior de un niño a la hora de... También hay que proteger y también, lo hemos visto en la película en primera plana y lo hemos visto en muchísimos documentales y quienes también trabajamos, el daño que produce la agresión sexual a un niño, y estos abusos sexuales normalmente no son violaciones violentas, no son agresiones sexuales en la calle, en un bus, en un tren, sino que son violaciones que las produce un familiar directo que ejerce una relación de autoridad, el caso de un sacerdote, como muchos casos, un profesor, personas que tienen una relación de autoridad y que generan un daño muchísimo más grave y muy difícil de superar. Y a veces nos toca ver en juicio a víctimas y decimos, bueno, pero yo veo que no sufre. A veces los jueces quieren ver víctimas que lloren de forma desgarrada. Y a veces hay víctimas que logran denunciar muchos años después a partir de, habiendo atravesado procesos, lo que se denomina la dissociation, ¿no? Poder haber excluido el evento traumático por mucho tiempo para sobrevivir, pero con efectos devastadores sobre su psiquis. Entonces, ver una persona que sufrió una agresión sexual y a veces subestimar, decir, bueno, pero no se la ve tan mal, esta persona, si no logra canalizar y entender, siendo que aquí prácticamente todos somos abogados y de alguna manera u otra ligados al sistema de justicia. Para este tipo de víctimas, la reparación judicial o la verdad o el perdón son elementos, digamos, casi que están por encima o iguales a lo que significa una terapia psicológica para poder superar, ¿no? Por eso la importancia de quienes trabajamos en el área de la justicia de ser especialmente cuidadosos en este nivel de reparación. Y cierro con lo de España, que a mí cuando fui convocado hace 1 año y medio atrás para esta auditoría, me convocó el entusiasmo de pensar que esto, yo he sido un gran litigante en casos particulares y esto me ha permitido, además de, digamos, dirigir algún caso muy importante, sentir que quizás modificaba o mejoraba el curso de la vida de alguna víctima. Hoy en España nos estamos jugando una posibilidad de reparación masiva, y reparación masiva tiene que ver con la verdad, con que una institución pueda, donde tú has trabajado, Martín, en el tema eclesiástico, pero donde una institución pueda reconocer, pueda admitir errores, que también la sociedad quite la estigmatización. Quiero decir, ¿es definitivamente mala la institución eclesiástica? Yo creería, y muchos creeríamos que no. Entonces, pero lo que hay que superar este obstáculo, pero el desafío de promover una reparación masiva, y en nuestra experiencia como abogados, casi ninguna de las víctimas nos viene a nuestros despachos a decir, yo quiero ganar tanto dinero porque me pasó esto. Lo que buscan es una reparación, lo que buscan es que alguien reconozca la verdad, que el ofensor reconozca la verdad o que un juez diga, usted tiene razón, aunque aquella persona sea muy poderosa, le creemos y hay una condena. Por eso el valor que sigue teniendo en el caso personal y entre otros que me ha tocado llevar el caso de Grassi, ni hablar la investigación que se hizo en Boston Globe, bueno, el enorme trabajo que se ha hecho en Múnich y bueno, y el aporte muy, muy interesante de todas las colegas americanas, siendo que además nos hacen docencia porque Estados Unidos tiene otra implementación, no participa de la Convención de Derechos del Niño y, sin embargo, muchas veces vemos soluciones efectivas, ¿no? Así que, bueno, creo que ha sido absolutamente rico y no sé si hay alguna otra pregunta. Por aquí tenemos una. Si le acercamos, ¿quieres un micrófono? Sí. Ven a un micrófono. Toma esto.
Sí, mis últimos 10 años de práctica profesional ha sido contra la explotación sexual de niños, niñas, adolescentes y la trata de personas en mi país. Y hemos encontrado muchos desafíos, primero con el acceso a la justicia de la víctima y segundo con la reparación del daño, cuando ya acceden a la justicia y la decisión que emita un juez. Entonces, quiero saber de ustedes, ¿qué desafíos ustedes han identificado para facilitar el acceso a la víctima, el acceso a la justicia? Porque en mi país, lamentablemente, se ve muy normalizado el tema de la explotación sexual por el sitio turístico, porque nos venden como, lamentablemente, un paraíso de explotación sexual. Y a través de las ONG es donde hemos podido impulsar el acceso a la justicia de las víctimas para que el sistema de justicia responda. Ese ha sido el primer desafío. Me gustaría saber de parte de ustedes qué desafío han encontrado. Y segundo, luego de que acceden a la justicia y su caso es procesado y se obtiene una condena, ¿qué reparación de daño puede emitir o ha emitido el tribunal a favor de la víctima? Porque también nosotros ahí hemos encontrado muchos desafíos de qué indemnización le da un juez considerado justo ante un daño, como decía el colega aquí, de que si no la ven muy sufrida, de que si ven que fue algo normalizado, porque, ¿verdad?, muchas veces producto de la misma explotación crean mecanismos de defensa para aceptar su suceso. Entonces, eso hace también que al momento de imponer la condena o sea leve o no se repare de manera integral el daño a la víctima. Entonces, sí me gustaría saber qué desafíos han encontrado en esos dos aspectos.
Mira, como primero, recuérdame el país que dijiste.
República
Dominicana. Bueno, en mi experiencia he trabajado mucho en el área, no en Dominicana, pero muy particularmente en Honduras, también en Guatemala, y he trabajado también en trata de personas. Creo que, complementando lo que estábamos comentando, lo cierto que las dificultades para el acceso a la justicia, tanto en delitos sexuales contra niños, como propiamente en la trata de personas y en países particularmente ricos en turismo, sigue siendo muy alta la dificultad de acceso a la justicia, porque estos delitos, además, hace unos minutos hablábamos de la dificultad del equilibrio entre el derecho de defensa de un imputado y a la vez los derechos de ese niño. Lo cierto es que estos delitos, en mi experiencia y en la mayoría de los países, lamentablemente, a hoy, incluso son tasas bajas de acceso a la justicia, son tasas bajas de procesos judiciales que prosperen y son tasas bajas de procesos judiciales que terminen en condenas. En la Argentina en el orden del 3%. Entonces, ¿por qué? Porque también hay prejuicios culturales. Este delito, estos delitos, así como decimos que debe primar un interés superior del niño, por otro hay prejuicios culturales o históricos que hacen que muchas veces la víctima sea culpable hasta que demuestre lo contrario. Entonces, ¿qué pasa? Una persona imputada que tuviera las características de cualquiera de aquí, con traje, corbata y tal, y un niño dice, ese me provocó un abuso, o esa persona intentó trasladarme fuera del país, o esa persona, entonces, no olvidemos que el sistema cultural que nos ha regido por muchos años, casi no universal, conocido como un sistema cultural patriarcal, está en permanente tensión con los avances legislativos en esta materia. Entonces, si bien los estados en general, y cada estado, en el caso de Dominicana, ha suscrito la Convención de Derechos del Niño, como muchos otros, como también la Argentina, la aplicación de estas leyes tiene muchos obstáculos y muchas barreras culturales. Y digo más aún, cuanto más avanza la posición socioeconómica de las personas imputadas, o a veces también la idea familiar, ¿no? Fíjense que estamos hablando la cuestión de la Iglesia que hemos tocado aquí, una institución trascendente y que para muchas personas, yo digo, cuando explota el caso Gracia en la Argentina, y yo tengo mi primera reunión con el cardenal Bergoglio en el año 2006, yo realmente veía que Bergoglio no... O sea, hubiera querido que esto nunca ocurra, hubiera querido no tener la reunión conmigo, hubiera querido que nadie hablara de este tema y luego le toca ser papa y aún hoy no está resuelto el tema. Entonces son temas que tienen una barrera cultural. Puntualmente en el tema de la trata de personas también es cierto que hay un auténtico enorme negocio, ¿no? O sea, el tráfico de armas, la trata de personas son de los negocios ilegales más importantes a título global. Entonces, donde tenés barreras culturales, donde tenés un acceso a la justicia bajo, donde el Estado dice firmo tratados o leyes, pero que cada quien se arregle, donde tenés que la mayoría de los niños no tienen posibilidad de una familia de decir, bueno, busco un abogado y que ese abogado... Entonces, sigue siendo un desafío muy grande. Por eso creo que, para empezar, es impactantemente útil que este panel participe aquí en la American Bar Association y a través de la convocatoria de la World Jurist Association para discutir esto en el contexto del derecho internacional de los derechos humanos, porque es una asignatura pendiente y hemos escuchado a todos los panelistas de fuste, cada quien preocupado con sus aportes y en cada país, pero ningún país lo tiene del todo solucionado. O sea, no tenemos seguramente una respuesta definitiva para darte. Sí estamos reflexionando sobre estas dificultades que son bastante comunes, ¿no? Pero se requiere otra participación del Estado, un Estado que además de suscribir tratados, acompañe estructuralmente con más fuerza este tipo de fenómenos, pero bueno, también se choca con estas barreras que hablábamos, ¿no? Así que bueno, por allí hay otra pregunta. A ver si lo mismo, si te quieres acercar. Y la última. ¿Quieres contestar? Se nos ha acabado el tiempo.